Hi, everyone. Thank you so much for joining us at this presentation today. My name is Anna Bittencourt. My pronouns are she, her. I am an attorney with the National Association of the Deaf, also known as NAD. During this presentation today, I will be talking about two categories within law. One category is about required protections of people's privacy and their confidential information. The other category I'll be focusing on is required provider access for people with disabilities. I'll also be focusing specifically on deaf and hard of hearing students within the college and university setting. Next slide. Next slide. We have our title for today. The privacy laws that I will be talking about are on this slide here. So I'll be going over HIPAA and FERPA. With disability rights laws, we have the Americans with Disabilities Act and the Rehabilitation Act. So we see all these laws coming into play. And now when we have these two categories coming into conflict, what happens there? We do see some college and university campuses using private law to deny services for communication access for their deaf and hard of hearing students on campus. I'll be talking about this misconception and misunderstanding more and providing some resources that can be helpful in how to address these situations when they do arise and how to best advocate for communication access. Before we dive further into the presentation, I do just want to clarify, or actually make two disclaimers actually. A lawyer's favorite word, disclaimer. So the first one I'd like to make is that I do not have legal expertise in HIPAA or in FERPA. So I am not going to delve too deeply into the specifics of either HIPAA or FERPA and those two laws and how those are applicable. So I will be doing a more general overview. My primary focus is going to be on assuring communication access for deaf and hard of hearing students. Second disclaimer is if you are working at a college or university, it is really vital for any legal situation that you consult with your campus and with their general counsel that is provided. Your institution will have their very specific approaches they take in terms of HIPAA or FERPA and your students' confidentiality and privacy concerns. Now, what is HIPAA? The acronym stands for Health Insurance Portability and Accountability Act. And so this law was passed in 1996. It is a federal law mandating national standards for the protection of people's private information. And that information is called PHI, the protected health information is how we refer to it, PHI. So when anyone visits a doctor's office, the doctor needs to take an intake form. They're collecting a lot of private and personal information about the individual visitor to best be able to provide the services or make a treatment plan for them. With all of this information, what is the standard for how that office needs to make sure that all of that information is protected and it remains confidential and remains within their control within their institution? The laws themselves are also establish boundaries to make sure that there is appropriate use and distribution of that information. So the basic bottom line is that information cannot be disseminated or shared without the person's prior knowledge or consent. Next slide. Protected health information. There are many different categories that fall under this protected health information and what constitutes protected health information, anything that is spoken or signed, written information, electronic information, whether that be physical or digital images, That includes your physical mental health condition that you have, your whatever the provided healthcare you're getting, the payments that you are paying for that healthcare. Any of that information, whether it be past, present, or future, all falls under protected health information. So any identifiable information that can identify who that person is would therefore be classified as PHI. Next slide. Who is now required to comply with HIPAA? There's two main entities. The first one is titled as covered entities. This would entail health plans, healthcare clearinghouses, and healthcare providers. So this would be the doctors, your dentist, a psychologist, and the like. Nurses also fall under that category. And the second group would be business associates. This group is comprised of anyone who is not maybe directly working for the covered entities, but they're still providing services. So they have some form of contract. So we're making sure that those covered entities then are actually doing their job accordingly. So those are those business associates that could include law firms, attorneys, accountants, insurance agents, consultants, and advisors are all under that business associates. So anyone who may need access for a patient's confidential and private health information to do their job, and in order to provide their services for the covered entity. The business associates, keep that in mind because we will be talking about that category more later on in the presentation. Next slide. We're going to shift over to disability rights laws. Any businesses that are required to comply with HIPAA are also therefore required to comply with disability rights laws, which entails the Americans with Disabilities Act, ADA, and Section 504 of the Rehabilitation Act. So these two laws are requiring providers of auxiliary services, known as AA, so auxiliary aids services, to make sure that they are complying and providing communication access for deaf and hard of hearing individuals. So these services include service providers, such as sign language interpreters, oral speech interpreters, maybe cued speech, CART services, captioning, those all fall under these auxiliary aid services. And this can happen whether it be in person or provided remotely. So it could be any type of video remote interpreting, for example, VRI, or if it's happening through a cell phone, if you have any type of telecommunication relay service, that also falls under the disability rights laws. Next slide.
When you're using interpreting services, whether it be in person or in a remote setting, or maybe through a cell phone, the covered entity, meaning the doctor in this case, may use and disclose PHI, or protected health information, without the deaf person's authorization. This is true when these three situations are present.
So the first one would be the interpreter themselves is now a member of the workforce. For example, and the interpreter is contracted, maybe they're a staff employee for a specific hospital. The interpreter would be considered a business associate. They are not a direct employee of that hospital or institution, but they're still providing a service with their interpreting services. And then the third instance is if you have any person who is identified by the deaf person as their interpreter for that specific interaction. So this really can happen in pretty much any situation where interpretation services are provided and they are liable to follow HIPAA. So with this information, we see this coming from the HIPAA privacy rules that are disseminated by the healthcare departments and their human services. their HHS. So the final bit of this slide, I pulled that from you see the 45 CFR 164.510 in parentheses B and parentheses 2. So that's a federal regulation that is a privacy rule directly from HHS. And it specifically states that if a doctor is, whether they receive an agreement or if there's any type of inferred understanding based on the consultation or what's happening with the individual, the deaf person in that scenario, they're not object to the use of the interpreter. This slide is very specific about interpreting services, but it is still applicable to any service providers. That would include CART services as well, for example. Next slide. Let's move on to the next slide, please. Perfect. Can we back up one more? I think we skipped one. There we go. Great. So now with TRS, telecommunication relay services, this is with cell phone calls. So now we have a deaf person who is making or receiving a call via their cell phone to a hearing party. In this phone call, they will have a relay interpreter. So this interpreter is now facilitating that communication between both parties, the hearing and deaf person. Some issues that we see with this is that many entities or service providers refuse to accept relay calls, or they'll just hang up once they realize it's a relay call due to the belief that the operator is a third party. So there's a misconception that that interpreter providing the relay service is a third party. And we see this concern come about because it's believed to be a violation of HIPAA. Because having a third party or a third entity on the call is a violation of HIPAA. However, the sharing of PHI through TRS is still permitted. That is permissible. And again, we see that from the HIPAA privacy rules. It does state that. Business associate contracts are not required with relay service interpreting. So it would be almost impossible because every time we're now making a phone call as a deaf individual, that relay interpreter is going to be a new person every time. You're not guaranteed to have a consistent person. They work all over the United States. So you have relay operators in different locations. So it's not possible for them to be contracted as business associates with those interpreters in those types of settings. The FCC, the Federal Communications Commission, does already have their standards and requirements for TRS services to make sure they are in compliance, and they have very stringent confidentiality requirements for that in order to protect the privacy of anyone, of all relayed communication and anyone utilizing those services. So it's not just in terms of healthcare settings, but it really constitutes all relay communication. And it's very strict in the way that they must follow those rules and maintain confidentiality for those communications.
All right, next slide. So we'll have a little bit of fun here, shifting directions. There aren't too many cases or case law directly related with this conflict of privacy law and disability rights law, but there is one interesting case out of Alabama that I did want to share with you all. The name of the case is Howard versus Alabama Board of Pharmacy. And this case involved a deaf pharmacist who needed to use relay services at work to make phone calls. The State Board of Pharmacy refused to allow TRS because the Alabama code required that only pharmacists who are licensed or registered interns may be able to receive oral spoken prescriptions over the phone. And when Howard use TRS, the relay operator person was considered a third party on the call. So Hauer filed a complaint in Alabama in federal court the violation of the ADA and Rehab Act for his rights. And the argument was when they received prescription calls through TRS, she was not allowed a relay operator in that call to receive that prescription, to receive that call. In other words, the operator was not a third party, but the transparent conduit. And that is actually in the case itself. Eventually, that case was settled, and the case had some helpful information in regards to how relay operators, or really any interpreters, aren't considered a third party. They're just there facilitating communication between a deaf and hearing person. Next slide. So back to colleges and university settings. Colleges and universities do have an ethical and legal obligation to protect the privacy of students. And that includes both students' education and healthcare records. In addition to HIPAA, there's another law that applies in these settings, and that is FERPA, which stands for Family Education Rights and Privacy Act, FERPA. So FERPA protects the privacy of the students' education and their records, including treatment records. And this applies to providing students healthcare or any type of counseling services that they receive. So FERPA applies to obviously healthcare providers and administrative staff who are on campus. Next slide. So FERPA and HIPAA are pretty similar, and they have the same goal. FERPA applies to student medical records or counseling records at the college or university, and it protects the treatment records under FERPA, which is very similar to the protection under HIPAA. Both of these laws establish a minimum of privacy standards. So if your state law has stricter protections, then that would supersede what is required under FERPA and HIPAA. And that's why it's important to consult and talk with your college general counsel to see what your campus approach is for HIPAA and FERPA and the students' privacies. Next slide. So, like I've mentioned earlier in this presentation, there's a lot of misconceptions within the colleges and universities that interpreters or any other service providers like CART would be a violation of FERPA or HIPAA, because that'd be a third person during that communication with the student, and they would learn that information, that private information about the student during that exchange between the student and the other person. But, however, the service providers are already required to maintain the privacy of the education and healthcare records in accordance with FERPA and HIPAA already. Next slide. So this is maybe just a different perspective here. Deaf students Those included with medical students, nursing students. Sometimes those students have to treat patients as part of their clinical rounds or residency programs or whatnot, part of their degree requirements. If those medical students utilize interpreters or any other service providers, it does not impact HIPAA patient privacy rules when it comes to the patients that are receiving services or treatment from that deaf medical student or nursing student. Again, HHS, FCC, all of those have guidelines and information on this. And there also are confidentiality clauses in Service Provider Code of Ethics and Code of Professional Conduct. And those clauses already state the interpreter or CART or other service providers must comply to strict confidentiality rules in regards to the deaf person that they're providing services for and that protected information. Next slide. So earlier, I promised that I would share some resources that you can use to advocate for communication access when it comes to HIPAA or FERPA issues. So I'm gonna, you'll see a list of them on the next slide here. You can go to the next slide. These are some active links. The first two are from the Department of Health and Human Services, and those are their guidance and guidelines in terms of for HIPAA. The third one on here is a hyperlink for the Federal Communications Commission, FCC, their guidelines related with TRS. Again, that is more HIPAA related. And then the last link on here is the PTAC guidance, the Privacy Technical Assistance Center. And that is established by the U.S. Department of Education. And that's responsible for the third-party services that are under FERPA. So these resources hopefully will be helpful to you all when it comes to advocating or clarifying any misunderstandings or advocating for communication access for deaf and hard of hearing students at your institutions.